Greetings and welcome to Abuse of Process from American Jurisprudence. Condense this down to a nice little presentation so we can get through it quickly and easily and have a lot of memory markers in here to make it easy to access for later use. That said, nothing in this presentation is to be used, misused, or misconstrued for anything legal, lawful, personal, private, business, tax, financial, or otherwise, so please don't do this at home. That said, let's get to the presentation here. So we're on to abuse of process. That's condensed from the American Jurisprudence. The abuse of process, general considerations. An abuse of process arises when a party uses legal procedures primarily to secure an objective outside their lawful design. Now it's a tort, so the tort applies in both civil and criminal cases, emphasizing integrity in judicial proceedings. Courts view it as a misuse of the system that threatens the fairness of justice. So abuse of process is a misuse of the system. Here's an example. Abuse of process may generally be defined as the use of a legal process, whether criminal or civil, against another, primarily to accomplish a purpose for which the purpose was not designed. The application is the liability attaches when judicial processes are twisted into instruments for purposes the courts were never authorized to achieve. So the liability attaches when the judicial processes are twisted. Once the processes are twisted in unauthorized ways, then the liability attaches. Let's move on to slide 3. We have here the essence of the tort, the general considerations. The heart of abuse of process is using litigation to coerce results unrelated to the claims in dispute. Such misuse includes attempts to compel payment of an unrelated debt or force unwanted concessions. Because of its potential chilling effect on court access, judges strictly limit this tort. So, chilling effect on court cases also, that judges will use that as a reason to strictly limit it. Here's an example. Using the court's process as a weapon to compel another party to pay a different debt. Thus, the essence of a cause of action for abuse of process is a perversion of the process to accomplish some improper purpose. So, to make sense of that, the tort arises only when litigation is perverted into leverage for collateral gain rather than used for lawful adjudication. So again, it's using the process of one cause of action to gain something from another without a lawful adjudication. So let's look at the limits of judicial power and the abuse of process. Jump over here. Oh, we get a comment from King Cosmic that says, sounds like one of the big evils. Indeed, perversions of justice is always an evil. As it said that power without justice without power is impotence, but power without justice is tyranny. All right, let's get back to it. The limits of judicial power and abuse of process. Abuse occurs when litigants try to compel courts to act beyond their lawful authority. So when you see them stepping beyond lawful authority, that's an abuse. A lawsuit filed for legitimate purposes is not abuse, unless it seeks remedies the courts lack power to grant. You see this a lot in things like disputes over titles and such. This distinction preserves access to courts while preventing institutional misuse. So the distinction of the limits of judicial power is what preserves the access to courts while preventing the institutional misuse. So abuse of process occurs when someone attempts to achieve, through use of the court, that which the court itself is powerless to order. Interesting. Yet the court may order it still. That's the abuse. The abuse is established when litigation pressures the court to issue orders outside its jurisdictional or statutory authority. There's your application for the limits of judicial power in the abuse of process. It's established when litigation pressures the court to issue orders outside its jurisdictional or statutory authority. So a definition of process, we say abuse of process. What is process? King Cosmic here mentioned mixing public and private in family courts. Yeah, I'm not too sure if family courts is even a real court of law, but that's a digression for another time. Definition of process. When we say abuse of process, what do we mean by a process? So abuse of process claims requires the issuance of process invoking judicial power. Courts interpret process broadly to include, here we go, here's any of these are processes: pleadings, discovery, depositions, subpoenas, and motions. Abuse may therefore occur at any procedural stage, not just at the initiation. So, as our example from the text is, the process is interpreted broadly and encompasses the entire range of activities and procedures incident to the litigation process, including discovery and issuing of subpoenas. So each procedural mechanism that draws upon the court's authority carries the potential to be abused if turned to improper ends. So there's your definition of process. It encompasses pretty broadly anything that involves the litigation process. Filing a complaint, though, is not process. So the filing of a summons and complaint is not itself considered process for abuse purposes. So abuse requires the misuse of legal tools after they are issued, not simply beginning a lawsuit. That would be under something different. This distinction protects litigants' rights to bring claims without fear of immediate tort liability. Interesting. That's an important distinction right there. So the institution of a civil action by summons and complaint is not legally considered process capable of being abused, as would be required for a claim of abuse of process. So the application here is that the plaintiffs must demonstrate misuse of subsequent judicial procedures to sustain an abuse claim. Mere initiation does not suffice. So that in of itself, as just filing a complaint or petition, is not considered the process for abuse purposes now. Okay, distinctions from malicious prosecution. So here's our distinction. Malicious prosecution punishes wrongful initiation of proceedings. So this is the distinction here from abuse of process to malicious prosecution. The abuse of process punishes misuse after valid process has issued. The two torts share the two torts share concern for court misuse, but differ in timing and focus. So from our example here is malicious prosecution concerns maliciously or wrongfully causing process to issue, while abuse of process concerns the improper use of process after it has been issued. So our application, abuse is defined not by how a case begins, but how court procedures are exploited once they exist. Important distinction, I think is quite clear, timing and focus. And here's some other differences from malicious prosecution. Abuse process does not generally require proof of lack of probable cause. Wow. So abuse of process does not generally require proof of a lack of probable cause. It also does not require the original action to terminate in favor of the accused party. So this could be during litigation. These differences make abuse claims distinct and sometimes easier to plead. So our example here is, unlike malicious prosecution action, an action for abuse of process does not necessarily require proof that the action was brought without probable cause, or that the action terminated in favor of the party alleging abuse of process. So regardless of the outcome or the initiation of the original case, the abuse of process stands on its own. Abuse of process may be established without showing wrongful initiation or favorable termination of prior proceedings. Distinction from false imprisonment. False imprisonment occurs when liberty is unlawfully restrained, regardless of motive. The abuse of process requires misuse of lawful process to achieve ulterior aims. These torts differ in both intent and focus. So between the malicious prosecution, it's timing and focus, and the distinction from false imprisonment is intent and focus. Example here is false imprisonment is the unlawful restraint by one person of the physical liberty of another. And the application here is that false imprisonment concerns unlawful detention itself, while abuse of process requires ulterior misuse of judicial authority. So there we go. And then we have the general requisites of the elements of abuse of process. The courts generally require proof of improper use, ulterior purpose, and resulting damages. Some jurisdictions condense this into a willful improper act and an ulterior motive. So we have a willful improper act showing intent and their ulterior motive, proving that intent there. The elements ensure that only clear abuses reach liability. So these are the elements here. Some jurisdictions condense it to just willful improper act and ulterior motives. Others have improper use, ulterior purpose, and resulting damages. But I think this is probably the better way to go. Cause and effect. And then, of course, we have here as the example, the elements are 1, the improper use of court's process, 2, primarily for an ulterior motive or improper purpose, and 3, with resulting damages. So there it is from the text. And application is a successful claim requires showing both misuse of legal tools and intent to secure improper collateral ends. And Shaggy Hippie says, hit the like button, people. Yes, indeed. Want to get more people in here to be aware of this because this is quite important topics for us. Come on, I'm going to try to clear this thing out here. Come on. There we go. For us to be aware of. Jurisdictional element test. This is called the Ohio test. Ohio courts require proper initiation, perversion of proceedings, and direct damages. This approach balances respect for lawful process with accountability for misuse. Definitely separates it from the malicious prosecution with that first one. So example, a plaintiff must demonstrate 1, that a legal proceeding has been set in motion in proper form and with probable cause for the Ohio test. 2, that the proceeding has been perverted. And 3, that damages resulted directly from the wrongful use of process. Directly. So the application of the Ohio rule highlights that liability arises only when perversion of process causes measurable injury. So there's your jurisdictional element test in Ohio. Yeah, misrepresentation of facts. So there we go. So now we're on to the general requisites here for the willful act and mere motive. Wow. So motive alone cannot create liability without an act that misuses process. So you still have to have a misuse of process and a motive. Pursuing a lawsuit to conclusion, however spiteful, is not abuse. So pursuing a lawsuit to conclusion is not abuse, however spiteful. Abuse requires a demonstrable perversion of procedure. There it is, the perversion of procedure. No liability where the defendant has done nothing more than pursue a lawsuit to its authorized conclusion, regardless of how evil the defendant's motive. Courts distinguish between ill will and actual misuse, shielding ordinary litigation from abuse claims. So intent alone isn't enough. Now we're on to ulterior motive or purpose. Abuse requires a collateral objective beyond the proceeding itself. So it's retaliation, spite. I like this icon here. Retaliation, spite, or annoyance is insufficient if the process is used properly. The key element is extortion-like pressure for unrelated gain. So that's the key element, extortion-like pressure for unrelated gain. The ulterior motive may take the form of coercion to obtain a collateral advantage by the use of the process as a threat or a club. I think that's a physical club there, not the associations and clubs that we covered on a previous live stream. Oakland Love and Less TV, greetings. So the liability exists only when process is transformed into leverage for concessions unrelated to the litigation. All right, now we're on to the illustrative outcomes on an ulterior purpose. Ooh, that's illustrative outcomes on ulterior purpose. Courts have found abuse where foreclosure suits were filed solely to delay proceedings. In other cases, suits remain legitimate if process is confined to its intended use. So an example here, filing of wrongful foreclosure lawsuit with a motive to delay or prevent the completion of defendant's foreclosure constituted an abuse of judicial process. So this application is misusing litigation to obstruct a lawful outcome. It demonstrates the type of collateral purpose the tort prohibits. So in cases where a defensive lawsuit is filed to try to delay something that is actually a lawful outcome is considered an abuse of process. Injury or damages. Some courts permit abuse claims even when coercion fails. So it doesn't have to succeed in the coercion, it just has to be the actual abuse case in some courts. Others require proof of actual injury, as we saw in the Ohio test, or damages from misuse. Jurisdictions vary on whether harassment alone suffices. Ooh, so harassment alone can suffice for injury or damages. So example here is other jurisdictions require that a plaintiff plead and prove that injury or damages resulted from the irregularity of the process. So damages, without damages, a lot of the abusive process can become quite difficult to have upheld. The application here is whether damages are essential depends on local law, but injury strengthens any abuse claim. Malice and want of probable cause. Here's that icon again. Malice is sometimes required, especially for punitive damages. Lack of probable cause is generally not an element of abuse. So, lack of probable cause is not generally an element of abuse. Facts showing groundlessness may still prove ulterior purpose, though. So, an example here is generally, want of probable cause need not be established. However, facts are relevant to show an ulterior purpose. So maybe not probable cause, but facts that are relevant to show an ulterior purpose are. Courts may infer improper intent from knowingly baseless claims, even where probable cause is not formally required. Wow. Termination of proceedings and mere filing. Oh boy. King Cosmic says, I wonder This goes with deceptive language. Damages is what matters. And if the deceptive language would lead to damages, it seems that's where your cause of action would lie. Abuse of process claims usually do not require favorable termination of the underlying action, so it could be concurrent, it seems. However, claims may be premature before the initial litigation ends. So again, the damages might occur after litigation. Filing alone without misuse does not establish abuse. Remember, the filing may not be, it may be malicious, but it may not be, but it's not abuse. So, example here is no right of action exists if the action is confined to its regular and legitimate function, even if the plaintiff had an ulterior motive. The application here is courts shield ordinary lawsuits from liability unless plaintiffs can show misuse beyond legitimate litigation steps. All right, and we're on to the misuse of discovery or deposition procedures. Discovery abuse arises when procedures are used primarily to burden the opponent. The abuse requires proof of ulterior purpose and an improper act. Proper use of discovery, even if burdensome, does not qualify. So abuse may lie when 1. The party intends to increase the burden, and 2. The use cannot otherwise be said to be legitimate. So the application here is courts sanction discovery abuse only when tactics shift from fact-finding to deliberate harassment. So there's the distinction here. The courts will sanction discovery abuse only when the tactics shift from fact-finding to deliberate harassment. Deliberate. Seizure of property under legal process. Misuse or improper care of seized property. Abuse includes seizing more property than justified, or seizing property not belonging to the debtor. Custodians are liable when they mishandle lawfully seized goods. Both overreach and neglect can transform lawful seizure into tortious abuse. So an example here, such as seizing more property than is known to be required to satisfy the debtor's claim, or knowingly seizing property that does not belong to the debtor. This is quoting from a case involving, must be a bankruptcy here with debtor, but however, this is referring to any kind of property that is seized under legal process. So seizure becomes abusive when carried out excessively or without regard for rightful ownership. Proceedings and arrest, generally. Legitimate arrests and prosecutions are not abuse, even if motivated by spite. Again, the intent isn't enough. Abuse arises when arrest is used to coerce unrelated concessions. The dividing line is whether process is serving justice or extortion. Key one there. The dividing line is whether this process is serving justice or serving extortion. Example here is a warrant of arrest is used to extort money or other property. There is an abuse of process. So arrest transforms into abuse when leveraged to compel action outside the bounds of the criminal charge. So there's another abuse of process involving arrest. Use of criminal process to enforce collection of debt. Criminal processes may not be converted into a tool for collecting civil debts. Proper prosecution remains lawful, even if indirectly pressures the payment. So the proper prosecution, even if it indirectly pressures the payment, if it's something where the criminal process is used to enforce it. Abuse arises only when affirmative misuse beyond ordinary procedure. I'm sorry here. The proper prosecution of criminal process is lawful even if it indirectly pressures the payment indirectly. But the abuse arises only with affirmative misuse beyond ordinary procedure. So the misuse would be outside the ordinary procedure, so it wouldn't be an indirect, it would be more direct of the affirmative misuse. Such use of criminal process will not constitute an abuse unless the defendant has undertaken some action which amounts to a misuse after it has been issued. So, our application here to make it simpler, criminal proceedings become abusive when defendants use them as disguised collection mechanisms. So, that's what a lot of the bankruptcy protections are there to protect from these kinds of abuses of process, because again, these are usually done through the local courts. See, King Comic, yes, that last one was a big one there. Bill Thomas says that the deadbeat dad laws must be okay because the collection of debt is part of the law. Well, that's a whole nother story there because of the way they're collected through the courts, as a bank almost, but that's, I digress. So we're on to persons liable. Procuring, aiding, abetting, advising, consenting, or ratifying. Whew. Liability extends beyond direct actors to those who encourage, aid, or ratify misuse. Non-litigants may be liable if they actively participate in the abuse. The law treats all participants as joint tortfeasors. Liability extends to all who knowingly procure, participate in, aid, or abet the abuse are liable as joint tortfeasors. So anyone who furthers abusive conduct shares responsibility for its consequences. Then we have the ministerial officers and deputies. Officers lose immunity when they misuse their authority under legal process. Deputies and other subordinates share liability for abusive acts. Public officials may also be accountable for oppressive misuse. So here's an example. An officer who improperly seizes property, uses excessive force, forfeits the protection, and becomes liable in damages like any other private individual. So an officer who improperly seizes property and uses excessive force forfeits his protection and becomes liable in damages like any other private individual. The application here is legal authority provides no shield when officers twist process into a tool of oppression. Key point here, I hope everyone's paying attention to this one. King Cosmic says, facts deceptively making you a public trustee. Yes, and in this part here is one of the most overlooked, I believe, in ministerial officers and their deputies, is that legal authority provides no shield when the officers twist process into a tool of oppression. Now we're on to the judicial officers. Judges generally enjoy immunity when acting within jurisdiction, but the immunity disappears if a judge acts wholly without jurisdiction. Debate continues over whether corrupt motives affect immunity. It still continues. So an example is a judicial officer generally enjoys exemption if jurisdiction and in a judicial capacity. But judicial immunity protects error within jurisdiction, but does not cover actions taken without lawful authority. So you see the immunity is not absolute. Attorneys, liability privileges or immunities. Attorneys may be liable when they misuse process for purposes unrelated to client advocacy. Professional privileges sometimes shield conduct. Professional privileges, I like that one. Sometimes shield conduct? but not all actions are protected. Courts distinguish zealous advocacy from abuse. Here's an example. The mere institution of legal action by an attorney does not constitute abuse of process. There must be a showing that the attorney performed some additional act. So attorneys cross into abuse when they go beyond advocacy to misuse process as a coercive tool. Now we're on to client as derivatively liable for attorney's abuse of process. Be careful who you choose. Attorneys act as agents, but abuse falls outside implied authority. Clients are not automatically liable for their attorney's undisclosed misconduct, but liability remains with the attorney who misuses the process. So here's an example. When an attorney has, without knowledge or consent of his client, abused process, the attorney has acted outside the scope of his agency, and the client is not derivatively liable. So the client escapes liability when attorneys abuse process without their knowledge or consent. Here's some more actions. Generally, joinder and remedies. Abuse of process is a personal tort and may be joined with other claims. Remedies include compensatory damages, restitution, and injunctive relief. These all come with the abuse of process. It's a personal tort and can be joined with these other claims. Courts prevent wrongdoers from profiting from abuse. The recovery may include both compensatory and punitive damages. Money extorted may be recovered. The application here is remedies aim both to restore losses and to deny abusers any benefit from misconduct. Beautiful here. These are generally the joinder and the remedies for abuse of process. The remedies aim to both to restore the losses and deny abusers from any benefit from misconduct. Okay, we're on to the jurisdictional considerations. Defendants may face suit in the forum where they initiated abusive litigation. Courts examine fairness and foreseeability when asserting jurisdiction. And conspiracy jurisdiction extends liability based on co-conspirators' contacts. So here's our example. It was scarcely unfair to make those who had initiated a lawsuit in a particular state to undergo a suit in that state to determine whether the lawsuit was tortious. So it was scarcely unfair. These are great ways to confuse people. It was scarcely unfair to make those who had initiated a lawsuit in a particular state to undergo a suit in that state to determine whether the lawsuit was tortious. So our application from that word salad was jurisdiction is proper when abusers could reasonably foresee consequences in the forum. All right, so that's our jurisdictional considerations. Again, the courts are looking at fairness and foreseeability, and the defendants, depending on what kind of case it is, they may face suit in the form where they initiated the abusive litigation. So whoever was the defendant in this case here, because they are being accused of abusive process, they may have to face suit in that same forum, which seems a little confusing in some cases, but that's why it says may here. All right, so we're on to the pleading. A complaint must allege essential elements as facts, not conclusions. So when it comes to abuse of process, you're not going to be pleading conclusions or making allegations of outcomes or speculations, but the complaint must allege essential elements as facts. Malice may be inferred from factual allegations where required. Then conclusory statements are insufficient to withstand dismissal. So you're going to get dismissed if you have conclusory allegations in there. Stick to the facts. So here's an example. Facts, and not conclusions, must be alleged. Thus, conclusory statements are insufficient. So abuse claims survive only when pleadings present concrete factual allegations of misuse. So that's the key one there. Factual allegations of misuse, not conclusions. Say, well, therefore this happened. No, these are factual allegations of the misuse. Oops, wrong way. All right. And speaking of that, let's get right to the proof. The plaintiff bears the burden of proving misuse and ulterior purpose. So we have both the process misuse and the ulterior purpose for doing it, the motive. The joinder and misjoinder are some of the biggest. Yes, indeed. That was an important slide there. Guys need to review that again. You can. I would highly recommend it. I think we stayed there long enough anyways because I want to make sure these points are getting through. The proof here is that the plaintiff bears the burden of proving the misuse and ulterior purpose. The improper acts cannot be inferred solely from the motive. So again, the motive is not enough to infer the acts, the factual statements of how the misuse occurred. That's how it is essential to be able to infer. The motive alone is not going to be enough to get the improper acts considered abuse of process, so risk dismissal. Courts may infer motive from conduct and surrounding circumstances, though. So facts of these things, surrounding circumstances as stated as facts, and conduct stated as facts, that may help infer the motive. But the acts cannot be inferred by the motive. You can't say that because he felt he didn't like the guy that he was engaged in abusive process. It would be the facts of, there was ex parte communications or all these surrounding circumstances. Then you could start to see there's probably some motive as you put these things together in the bigger picture. So improper acts may not be inferred from the existence of an improper motive alone. If the act is in itself regular, the motive is immaterial. So there you go. The motive won't be part of the central accusation here or allegation. And the application here is that proof requires evidence of perverted acts, not just hostility or intent. We're on to defenses now. The limitation of action, recoverability of damages, and punitive damages. So defenses include good faith, statutory privilege, or advice of counsel in mitigation. Statutes of limitation vary, often starting when the abusive act ends. But check your local jurisdiction. Plaintiffs may recover compensatory, special, or punitive damages where malice is shown. So example here, in an action for abusive process, the plaintiff may recover whatever actual damage the plaintiff has suffered as a natural and probable consequence of the abuse, the actual damages. So these are what receipts, not speculative, not nominal, but actual. So the application here is courts compensate foreseeable injuries and impose punitive awards when malicious misuse warrants deterrence. So a key application here to be aware of. Otherwise, you're stuck with actual damages. And that brings us to the conclusion. Proper process. Legal procedures must be used for their intended purpose, not as tools for collateral gain or coercion. Balanced justice. Courts must preserve access to justice while preventing institutional misuse of legal process. That's the difference between the malicious filings and the abusive process. That the courts must preserve access. Just because someone is angry that doesn't bar them from having access to justice. But once the access has been initiated, then there must be a prevention of any kind of misuse, intentional, institutional, or otherwise, of that legal process. And the accountability. All participants in legal proceedings bear responsibility. All the participants bear responsibility for ensuring processes are not perverted for improper ends. The integrity of our legal system depends not only on the rights it protects, but on the responsibility with which we exercise those rights. All right. And with that, it takes us to the end of the presentation here. I'd like to thank you all for coming in here and giving your feedback to the abuse of process condensed from American jurisprudence. Please hit the like to make sure that plenty of people get the word out that we're studying this and as how important it is for us and the posterity of the system we have in place of our American jurisprudence. And what really makes it all work is respecting the processes that have been worked out over time and preserving them to the best we can to ensure the equal access for everyone and the ultimate finding of facts of truth regarding the law. With that said, I'd like to thank you all for coming. Salute to you, and we'll see you on the next one. Peace out.